As President of the Institute, it's a very great pleasure to welcome you all here tonight to this joint event with the Caldor Centre for International Refugee Law at the University of New South Wales and the Law School at Macquarie University. I'm just making this very brief introduction and handing over to Leanne Smith, who's the Director of the Whitlam Institute. Leanne will be moderating the discussion and conducting the question and answer session, and you won't see much of me until right at the end. Again, a very warm welcome, and over to you, Leanne.
Thank you very much for that introduction. Good evening, everybody. I'd like to start off tonight by acknowledging that we're meeting tonight on the land of the Gadigal people of the Eora Nation and pay my respects to their elders past and present. I'd also like to take this opportunity to welcome any Gadigal or other First Nations people who are with us this evening. Welcome to all of you. I assume some members, maybe some not, of the AIIA. It's great that you could join us this evening. I'd like to start off as well by thanking the organisers of tonight's event. So a big thank you to the Caldor Centre for International Refugee Law, the AIIA, and of course Macquarie University Law School. My name is Leanne Smith and I'm the Director of the Whitlam Institute based out at Western Sydney University. We're a public policy and civic engagement think tank institute, and we base a lot of our work on the principles of social democracy and social justice. Prior to that, I practiced as a human rights lawyer in Australia and abroad, as an Australian diplomat, and also as a UN civil servant, serving apart from in the fabulous location of New York City, also in Afghanistan, South Sudan, and the Balkans. Most recently, I've just come back from New York, where I was the Chief of Policy and Best Practice for UN peacekeeping. So tonight, we are all gathered here to explore the topic of how states influence each other's asylum policies, particularly in relation to deterrence. And we're also here to examine the role that diplomacy, as well as individual diplomats, play in that endeavour. We've got two keynote speakers this evening, Dr. Daniel Gezelbash from Macquarie University, the author of Refugees Lost, Asylum Law in an Interdependent World, and eminent legal scholar Guy Goodwin-Gill, who's the Acting Director of the Caldor Centre for International Refugee Law. Unfortunately, our third panellist was unable to join us this evening due to unforeseen circumstances. Daniel and Guy will both speak for around 15 to 20 minutes, and then we'll open the floor for discussions, and I'd be glad to field any and all questions and comments. So we've got just around an hour for our discussion this evening. Now, I was delighted to be invited to be part of tonight's discussion because this topic that we're going to discuss tonight is one that I've had to grapple with in many different contexts during my own career. As a young international lawyer in the Department of Foreign Affairs and Trade International Legal Division in 1999, one of the first pieces of advice I was asked to provide to the Minister was a comparative study of different countries' refugee detention policies. Even at that time, Australia did not stack up well, let's just say. It would be unprofessional of me to tell you how my advice was received by the Minister for Foreign Affairs at that time. But suffice to say, it was certainly a wake-up call about the direction of our diplomacy on refugee issues going forward. Then, as a human rights lawyer working in Afghanistan for the UN assistance mission there, on secondment from DFAT, I was at times called up by the Department of Immigration here to give my own personal assessment of the conditions for refugee return for particular ethnic groups in a particular part of the country. It was never clear to me during those inquiries whether the advice was being sought formally or informally, or indeed what impact the advice I was giving to them had on the case or on the lives of those individuals. The last way I've kind of come up against this issue most recently, I suppose, is as a UN civil servant in New York for the last 8 years or so. And I was observing the casting and the recasting of different countries' conceptions of their national interest and how they played out in different UN fora, from the General Assembly and its committees to the Security Council and other convention-specific kind of gatherings. One country could take absolutely polar positions in two different committees meeting in the same building on the same day on any given issue. So the complexity of multilateral negotiations, underpinned by each country's national interests, as well as bilateral and regional relations, is certainly not something to be underestimated. It's amazing to me how a country position on one issue, such as refugee deterrence, for example, can be built on a myriad of considerations, specific to, say, a domestic election, a regional security arrangement, or the national position of another country with which an important trade deal is imminent. The possibilities are endless. As Professor Bill Maley noted in his book, What is a Refugee? In the chapter he wrote on diplomacy and refugees, he said, "The lesson here is that in the absence of political will, the mere existence of a diplomatic framework for multilateral engagement may count for relatively little." I'm afraid I think I saw a lot of that at UN headquarters. At the Whitlam Institute, we are particularly interested in the interface of domestic and foreign policy. And for me, this issue of refugee policy is one of the clearest examples of the inherent challenge we have in demonstrating consistency across those two different spheres. What image of ourselves as a society do we seek to promote abroad? And how do Australian values translate in our diplomacy around refugee policy? How is our stance on refugees and on refugee deterrence affecting our broader international standing? So with these introductory questions in mind, let me turn now to our first speaker. Dr. Daniel Geselbach is a senior lecturer at Macquarie University School. He's the founding director of the Macquarie University Social Justice Clinic and a practicing refugee and immigration lawyer. His new book, Refugee Lost, Asylum Law in an Interdependent World, analyses the way restrictive asylum policies are spreading around the world. So David, welcome to the podium. We look forward to hearing what you have to say.
Thank you. I too would like to start by acknowledging the traditional custodians of the land on which we meet, the Gadigal people of the Eora Nation. And I pay my respect to the elders past and present. And I also want to extend my very deep gratitude to the AIIA and the Caldwell Centre for International Refugee Law for all their efforts in putting the event together tonight, and also for all of you in the audience for coming out to hear what we have to say. So I'm going to give you a quick overview today of some of the themes from my book, Refugee Lost, Asylum Law in an Interdependent World, which examines the issue of the spread of deterrence policies across jurisdictions. And I'm going to start with a little bit of history about the origins of the Refugee Convention and where it came from. So it was developed in the aftermath of World War II, largely in response to the failure of states to accept those fleeing Nazi Germany at their borders. So the picture I have up here of this is of the St. Louis vessel, and the story of the passengers of that boat provides an instructive example. So they set off from Hamburg in May of 1939, a little over 900 passengers, mostly Jews fleeing Nazi Germany, and they all had landing documents that would let them land in Cuba. So upon arrival, the Cuban government decided that they didn't want to let them in, and so they were pushed back out to sea, where they tried to make to disembark at Miami, and they made it within sight of Miami. They could see the lights in the distance, but they were stopped by U.S. Coast Guard vessels and stopped from entering the United States. There was negotiations with Canada to get them disembarked there, but they fell through, and ultimately the boat was returned to Europe, where the passengers disembarked at a number of different European countries, some of which subsequently fell to the Nazis, and basically they estimate around a quarter of these people end up dying in concentration camps. And it was this memory of this event that weighed on the minds of the drafters of the Refugee Convention when developing protections for asylum seekers. And the cornerstone of that convention is the idea of non-refoulement, which is that people should not be returned to a location where they face certain types of persecution. But we have entered, I guess, dangerous times with respect to the state's attitude towards these hard-won protections. And we've entered what some describe as a deterrence paradigm, where states are continuing to pay lip service to their obligations under the Refugee Convention, but bending over backwards to come up with new and innovative ways of keeping asylum seekers from actually accessing these protections. This deterrence paradigm provides really fertile grounds for the transfer of policies between jurisdictions. And policy learning happens in all areas of law and policy. It makes sense to keep track of what other countries are doing when developing domestic policy responses. But there's a few characteristics about asylum policy that make it particularly susceptible to transfers. So the first issue is that, or the first factor is that states generally share very similar policy goals. And these days, unfortunately, the deterrence paradigm is designed to try and keep asylum seekers away from their territories. But they're also operating within the same international framework. They face the same external constraints to meeting these goals, which are the protections in the Refugee Convention. And when a state comes up with, I guess, an innovation that pays lip service to those international obligations while achieving the goal of deterrence, it can spread like wildfire amongst people operating in that paradigm, against governments operating in that paradigm. And the other factor that makes asylum policy particularly susceptible to transfers is the fact that there is interdependence between the policy settings in different jurisdictions. So, in a very direct way, when a state decides to reject someone at the frontier or to push back a boat at sea, the asylum seekers on that vessel, the asylum seekers are pushed back onto another state. On a more indirect level, there's a perception that when a state introduces restrictive asylum policies, then it pushes asylum seekers to go seek refuge elsewhere. And so it creates a sense of competition, which I'll come back to, in which states view themselves as being in direct competition with other destinations, and this race to the bottom of developing progressively more restrictive policies. So, Australia's asylum policies provide an instructive example of this, and our current suite of border control policies has been very much modelled and taken from the US government playbook. Mandatory detention, which we introduced in the early 1990s, was practiced in the United States with respect to Haitian boat arrivals going back to the early 1980s. The maritime interdiction and pushback at sea were also carried out against Haitian asylum seekers by the United States from the early 1980s, and the US maritime interdiction program has been expanded over the years to target boats from other Caribbean nations, Cuba, also from boats from further afield, like from China, and also our offshore processing system. So our policy of sending asylum seekers to Nauru, Manus Island is modelled on the US precedent of using its territory in Guantanamo Bay as a migrant processing centre. And the rationale for using Guantanamo Bay was that it has a special, it's purported to have a special legal status. And asylum seekers sent there don't have access to the same legal protections that they would if they were held on the mainland. And it was the same rationale which led the US government later to use it as a location for holding any combatants captured in the course of the war on terror. There's also US precedent for using third countries for processing, very similar to what we do in Australia. So in 1994, when to augment the capacity of Guantanamo Bay, the US government operated a Navy warship based in the harbour in Kingston, in Jamaica, which was used for processing asylum claims. And again, for those same reasons, because it was extraterritorial, the same legal rights that would apply on the US mainland were said not to apply there. And this is exactly the same rationale behind offshore processing policies in Australia. We didn't have the equivalent of the Guantanamo Bay, and so we created our own exceptional zones through agreements with our Pacific neighbours. And my assertion here about policy transfer in Australia from the US isn't just based on a hunch or on the fact that these policies look really similar on paper, For my book, I carried out extensive interviews with US and Australian policymakers involved in developing these policies. And I spoke with a particular US policymaker who was largely responsible for developing the offshore processing regime in the United States in the early 1990s. And he reported that he provided very detailed policy advice to the Australian government. And this occurred in the context of the Tampa affair back in 2001. And if you recall, the Australian government was holding 433 asylum seekers and the crew of the Norwegian tanker, the MV Tampa, at sea, and was scrambling to find a solution that would stop the asylum seekers from disembarking in Australia. And it's these moments when governments are looking for a quick solution that I guess lend themselves most easily to this temptation to look abroad. And this particular US policymaker was summoned to the Australian embassy in Geneva, where he was based at the time, and basically in crisis talks for 2 or 3 days, providing detailed policy advice, which basically provided the blueprint for a specific solution, and again, by extension, our current operating sovereign borders. So, this transfer of restrictive asylum policies and transfer of deterrence is a live issue. It's not just a historic one. There have been recent calls for Europe to adopt the Australian model in response to the migratory pressures they're experiencing now. And I mean, the irony is that really we should be talking about the US solution, not the Australian solution. But it highlights, I guess, an interesting difference between the approach of the Australian government and the US government on this issue. By and large, the US government has gone about these policies quietly, whereas Australian leaders have felt compelled to go out on the international stage and spruik our approach basically as a model for others to follow. So we had a former Prime Minister, Tony Abbott, shortly after he was deposed as Prime Minister, heading over to Europe for a grand tour, basically called on European leaders to adopt Australia's approach. In his Margaret Thatcher lecture, he explained what this meant in practice. He said, this means turning boats around for people coming by sea. It means denying entry at the border for people with no legal right to come. And it means establishing camps for people who currently have nowhere to go. It will require some force. It will require massive logistics and expense. It will gnaw at our consciences. It is the only way to prevent a tide of humanity surging through Europe and quite possibly changing it forever. And in many ways, it's this call has met with, I guess, a receptive audience in Europe. And I won't talk about the European response too much because Professor Bill is going to talk about it. But at first we saw calls for the Australian model being adopted, picked up by the far right, and we see it slowly moving further towards the centre, and even some progressive parties like the Social Democrats in Denmark now calling for the introduction of offshore processing. So just to wrap up, I wanted to highlight some of the risks of this diffusion of deterrence. And I want to put to one side the very serious issues related to the financial and human costs of the policies that we're talking about today. They've been well documented elsewhere. My focus is on the risk of the actual process of diffusion. So my first major concern is, I guess, the quality of the policy making that's resulting from this process of diffusion. As my anecdote about Australia learning from the US with respect to offshore processing illustrates, the discussions that lead to these policy changes take place behind closed doors. And we don't have any information about what governments are claiming in terms of the effectiveness or the justifications for these policies, and what the information governments are relying upon to make these drastic policy changes. So the other main forums that my interview respondents cited as being important for the diffusion of asylum policies were the regional consultative processes. So these are informal, closed-door meetings in which governments with similar interests get together to discuss migration policy and asylum policy developments. So the important one for the diffusion of Australian and between Australia and the United States was it was and continues to be the Group of Five meetings, which include Australia, Canada, the UK, New Zealand, and the United States. And again, by definition, these are closed-door meetings that aren't open to the public, they're not open to NGOs. And so I guess my message is that there's nothing wrong with learning from abroad. In fact, it makes perfect sense to learn from what other jurisdictions are doing. But the policy diffusion process needs to have more transparency. There should be more opportunity for NGOs and other interested parties, concerned citizens, to engage in that transfer process. My other main concern relates to the point I flagged earlier about sort of competitive tendencies that can underlie the transfer process. And I'm just going to read a paraphrase quote from my book on this. So the risk is that we'll see a race to the bottom as countries compete to deter asylum seekers. This competitive approach creates a vicious cycle in which governments seek to outdo each other by implementing progressively more restrictive policies. When devising asylum policies, governments weigh up their competitiveness in deterring unwanted immigration against the value of abiding by their obligations under international law. As more states opt for deterrence over protection, this places pressure on other states to do the same. This scenario has and will continue to have a devastating impact on the ability of those in danger to seek safety. The protections set out in the Refugee Convention and other human rights treaties are only words. Their effectiveness in the real world is shaped by the actions of states. Implementing international law requires leadership. It needs states to lead by example to persuade other states to protect refugees. This role has traditionally been carried out by wealthy liberal democracies, which have had the resources and the legitimacy required for the task. The harsh policies introduced in the United States and Australia mean these nations now lack the credibility to take on this leadership role. All eyes are now on European states. If Europe goes down the same path as the United States and Australia, it will be inflicting a mortal wound on the universal principle of asylum and the international refugee protection regime more broadly. And sadly, we'll see a return to asylum seekers facing the predicament of those aboard the St. Louis, the vessel I started off my presentation with today, where they are out at sea with nowhere to seek protection. Thank you.
Thanks very much, Daniel. I look forward to reading the book, and not the most optimistic ending you gave us there in your presentation, but sage indeed. Our second speaker tonight, Professor Guy Goodwin-Gill, is the Acting Director of University of New South Wales Kaldor Centre for International Refugee Law. Widely recognised as the preeminent legal scholar in the field of international refugee law, he is Emeritus Fellow of All Souls College, Oxford, and Emeritus Professor of International Refugee Law of the University of Oxford, and practices as a barrister from Blackstone Chambers in London. Welcome, Guy.
Thank you very much, and thank you also for the occasion to speak. I'm delighted to be able to speak to Daniel's excellent book, Refuge Lost, because he brings a large measure of light to bear on a topic which is really under-examined. As refugee lawyers, as practicing lawyers, as advocates, we are used to jurisprudence crossing borders. Good cases travel quite fast, opening above ground. Courts throughout the world are quoting each other very often on matters of interpretation of the Refugee Convention and on the grant of asylum and protection. Policymakers and legislators, however, as Daniel has exposed in his book, too often seem to prefer to work on the dark side. Now, what I think Daniel has also shown in his book, perhaps sometimes indirectly, are the limits of unilateralism. particularly when one compares, and I take a slightly different perspective on these issues than he does, particularly when one compares the options available to a government that is subject to the rule of law, to control by, for example, institutions, supervisory human rights institutions, and a government which has no such constraints or which perceives itself to have no such constraints. And I think what his book also exposes is some deep democratic issues. And I do seriously believe that we are at risk in relation to what's going on with regard to refugees and asylum seekers, of seeing our broader conception of liberties deeply undermined. There is, of course, a long history, and naturally, of course, amongst policymakers and legislators relating to policy-making, consultation, exchange and adaptation. When I was working with the Office of the UN High Commissioner for Refugees, after my time in Australia, I was in Geneva, we were joined by a Swedish official on secondment from the Ministry of Immigration, Jonas Widgren. And he didn't have a happy time, he's since passed away, but he didn't have a happy time in UNHCR because in our perception he never really grasped what it meant for the international community to provide international protection to refugees. Or perhaps he did grasp it, but didn't buy into it. He left UNHCR fairly soon and was instrumental in setting up the intergovernmental consultations, which was perhaps the first of these conclaves in which ministers and officials of like mind gathered together to discuss ways and means better to manage refugee and asylum seeker movements. Jonas is actually remembered also for one quite perceptive remark that he made looking to Eastern Europe and seeing the liberalisation that was then going on. He said, "We knew what to do if they came in tanks, but we don't know what to do if they come in buses." And I think that's quite perceptive, but also at the time and since then, I see it very much as an expression of fear and a confession of incompetence. And I think those are two factors which drive officials and policymakers to continue the processes which Daniel has described in his book. The intergovernmental consultations meet in Geneva. They have a secretariat in Geneva. Their website is not open to the public. We don't know what they talk about. We perhaps see the effects of what they talk about as we witness yet another disastrous policy in relation to asylum seekers emerging in this or that part of the world. Why do they meet in secret? What is so attractive about secrecy? Yes, one can understand also that states generally need and want to better manage the movements of refugees and asylum seekers. And there is a problem here, there is an issue there, because the refugee regime has always been incomplete. It never squared the circle. It talked about sharing responsibility, it talked about providing assistance to countries of first asylum, but never worked out a way effectively to translate that into measures on the ground. So why we find states so often talking about the necessity for deterrence and the necessity for deflection? Perhaps it is something that states do naturally. It's a sort of version of the beggar thy neighbour policy, which we know about in economics, enhancing one's own position by worsening that of others. When it comes to flows of people and the treatment of people, I do begin to wonder about the justification, the legitimacy of that sort of approach. So what is it that motivates officials, legislators, governments in the direction of negative refugee policies? They're not universal, but they're purposely they are too common after all. Is it perceptions of unfairness, a feeling that states need to protect themselves because the rest of the world will not come to their rescue? There is an element there, I think. Back in 1980, when Australia was admitting Indochina refugees, it was beginning to think a little strategically about the future, and about the present and about the future. And it promoted in the UNHCR a very important, indeed a seminal conclusion adopted by the UNHCR's Executive Committee on temporary protection. But the other agenda which Australia pursued at that time was in relation to international cooperation, because there was a very real apprehension that perhaps the rest of the world would look at Australia and say, that's a big empty country, surely you can take everyone and leave Australia to do it. But Australia, I think, strategically put into place an endorsement which other states were happy to follow on, about cooperation, about joining in multilaterally to relieve the burden on refugee-receiving countries and to assist in finding solutions. What else might motivate states towards the negative policies? It is, as I mentioned a moment ago, the absence which is perhaps going to be, if not remedied, moderated through the Global Compact on refugees, which is currently being debated. It's the absence of more effective, more equitable means of sharing responsibility and achieving solutions. Again, ideas that were put forward by the Secretary General of the UN in 1950, before states signed on to the 1951 Convention. The Secretary General pointed out that the whole system would depend upon cooperation, would depend upon lightening the burden on those countries in the front line. And he proposed that states accept obligations in that regard. Not that specific obligations, but general obligations to assist countries of first asylum and to admit a certain number, never specified, of refugees. States said no. Want nothing to do with that. No obligations in relation to the admission of refugees. And then again we come back to fear, and I think that is increasingly, in my view, a factor. Fear that is real, fear that is generated. The fear, the apprehension that by perhaps improving the treatment of the refugee and the asylum seeker, one would make the country too attractive to those obliged to flee and so consequently end up bearing more than a fair share of the burden of responsibility. But each of those elements, which I think may be present, nonetheless it seems to me do constitute a rather sad reflection on the state of our government. So we have, as Daniel has pointed out in his book very thoroughly, policies of deterrence, of deflection, of detention, and if we want another alliterative noun, damage, the damage that is done to those on the receiving end of these policies. And what he shows in his book also, and it's worth re-emphasizing, is that deterrence is and always has been an unproven assumption. It doesn't take much imagination, it doesn't take much intelligence to see that when what drives you to flee is so serious, you are not going to be put off by tales of deterrence. If you are desperate, if you are fleeing conflict or persecution, then you will put the best light, you will shine the best light on what awaits you. But of course, politicians, bureaucrats, generally have not spoken to refugees or learned to understand what it is that leads them to take risks that you and I would never take. We've seen that, so much of that in the Mediterranean, crossing the Mediterranean in recent years. Families doing what you and I would think was foolhardy. But these are perfectly, as we know from the research that's been done, perfectly rational choices. Individuals have weighed up the risks and weighed them against their current situation and decided that that is the only way. And that seems to escape the policymaker, the decision maker, who believes that they can effectively deter that movement by policies of incarceration without limit. And then the refugee himself, herself, the asylum seeker. So often I've heard this story when I was with UNHCR in particular, that innate belief that they have in the fundamental goodness of human nature. They're not necessarily thinking of the bureaucrats and politicians we know, but they so often think that, yes, there may be a policy of detention without limit, but once they hear my story, once they hear what I've been through, they'll understand and not apply it to me. But no, that is faith that is too often sadly misplaced. Daniel points out the hypothesis, the deterrence hypothesis, has never been tested. It is empirically unproven. Actually, I would say the contrary has certainly some evidence to back it up. The evidence of earlier deterrence models, Germany used it in the 1980s, for example, suggests that it's not a viable base for any policy towards those seeking to move. So what we have is, it seems to me, many elements which may help to explain, none of them necessarily controlling, may help to explain why it is that policymakers go for the hard choice. For a start, I think there's a public relations dimension. It's an easy sell. And when you listen to politicians talking about what they are going to do to asylum seekers and refugees, you can hear them thinking, I'm going to talk tough now. I'm going to show the asylum seekers and by extension my constituents, the voters, that we're going to brook no exception, that no one comes here without being invited first. So the PR side, I think, is important, and it's the electoral dimension, of course, that comes in here. Then there's a somewhat more worrying dimension too, and it's that desire, and I see it too often in ministries of immigration, ministries of home affairs, the desire always to maximize control, the vision that certain ministries have of themselves as gatekeepers, seeing themselves as finally the last bulwark against insecurity or threat. Borders, of course, are a useful place in which to develop that approach, the gatekeeper mentality. But what we know is that very often those measures of control will go beyond the border and come to affect us all. So I think there's that element too in this new Ministry of Home Affairs combining so many disparate elements, which poses potentially a most serious threat to the civil liberties which we take for granted. But it's an area in which also we find governments exploiting what are the grey areas. There are many grey areas in international law and regulation. Fear again comes in, the fear of the newcomer, of the other. And it's coupled also with incompetence, a fear, I think, amongst bureaucrats that we can't manage. And that's so seriously wrong, it seems to me, because we've shown that we ourselves can manage when people arrive unannounced. We can put mechanisms in place which allow us to deal effectively and well with those who claim protection amongst us. Now, what is often not so easy is following through and sending back to their countries of origin those who, after a proper hearing, have been found not to need protection. And we haven't been able to square that circle because we don't like to deal with the migration dimension multilaterally. We like to deal with it unilaterally, or to pretend that we can. So there's that element of competence as well, plus sometimes other worrying factors. Daniel mentioned the introduction of Haitian interdiction in 1981. Now that decision to start intercepting boats followed a couple of very interesting court cases in the Florida Southern District, a first instance judgment and a judgment on appeal, in which the federal courts found that in the years leading up to 1980, the Immigration and Naturalization Service had been discriminating against Haitian asylum seekers on racial grounds, and on the ground that they were poor as well. And there were a huge number in the backlog of Haitian asylum seekers, which the INS was unable, for those and various other reasons, to deal with effectively. And it was seen, it seems to me, Haitian interdiction was seen as an extension, if you like, of what were policies driven by race and other prejudice. And then there's the lack of strategic thinking, which I think has affected and led Australia to where it is today. The failure to implement a policy in cooperation with others. And that's a lack of imagination on the part of the policymakers, reflecting a sad unwillingness to cooperate meaningfully and effectively in providing protection and solutions. It's the lure of unilateralism, which we see too much of these days, which generally ends in tragedy. And the consequences, of course, and Daniel has set these out again in his book, the consequences of states adopting these negative policies have been serious in the extreme. Detention, arbitrary, because it's unreasoned and because it's detached from any viable end. And of course abuse and ill treatment. The government may pretend that it did not admit liability when it paid $70 million in compensation to just short of 2,000 asylum seekers and refugees, but we know that they were liable for that abuse and that ill treatment. And it's still going on. Abusive denial of medical care is still going on in Papua New Guinea and Nauru because of Australia's decisions. So sad. And when I say there was no strategic thinking, Australia had not thought through what it might have done. It might have said to the world, look, we cannot deal with those who arrive by boat, the rest of the world. If you help us out, we will triple our contribution to UNHCR, we will double our refugee intake. And they might have had some takers. But through not engaging multilaterally, Australia, as it were, ended up in the situation where it is now, having to be rescued by Barack Obama to some extent at least. The other consequence, I think, flows from that secrecy which I mentioned a moment ago. Like the interstate consultations themselves, which Daniel has highlighted, secrecy surrounds, as we know, the implementation of policy. Why? Again, I think I would put my finger on various elements. We are told, perhaps, that the policy and programs must be secret in order not to put the smuggling, the business smugglers, the smugglers on notice of what we're doing. That's sheer and utter nonsense, of course. There's no way that smugglers would be put off by what Australia is doing. They would be, I think, more likely to be encouraged to find ways and means around the measures taken and then to up their prices. But I think that what the secrecy is intended to do is to seek to avoid the responsibility of the state and to seek to avoid the civil and criminal liability of individuals from the top down for the consequences of the policies which they have applied. And it's here that I see the threat, this particular threat to democracy. Anyone who reads the Washington Post these days will know that their new flag is "Democracy dies in darkness." And I think there's a great truth in that simple label. And secrecy itself, it seems to me, reflects that anti-democratic tendency which serves the goal of an ever-expanding and unaccountable executive both here and elsewhere. We see it also, that tendency, within another dimension of the law reflecting that approach, which is the personal non-compellable discretion, which Daniel mentions in his book, which to me, to my mind, is also the antithesis of democratic and accountable decision-making. Now, I'm, as an international lawyer and someone who's worked in the field of refugee advocacy and protection for many years, I don't perhaps take such a pessimistic view of the future as Daniel does. There has always been, and there always will be, a tension between the obligations which states accept and their practice, which will always, it seems to me, seek to maximize self-interest. That's the nature of the game, that tension. It's what makes international law a dynamic area of law, and therefore quite exciting. But law always, like nature, abhors a vacuum. Domestic law may excuse for now what is going on, but there are other mechanisms of accountability, even though sadly they may sometimes seem too distant. It's interesting that a lot of talk has been generated by recent practices about the necessity for a Bill of Rights. And I was reminded of how when Britain was going through the process of decolonizing and setting up constitutions for states that would shortly be independent, it had a tendency of tacking on at the end of every new constitution a variation of the European Convention of Human Rights, an interesting exercise in exporting, which didn't often take root, but nonetheless I think it was an interesting example of trying to move bills of rights around the world. Unfortunately, of course, as we know, Australia's constitution was adopted too early for that to be attempted. We do have a major, as I've said a moment ago, I think, a major democratic deficit, particularly because the traditional controls which we're used to in democratic society by way of judicial review tend to be weak, and the system overall tends to be out of balance. But from an international law perspective, it looks somewhat different. We do have principles of state responsibility which are indisputable. They flow from, for example, the exercise of authority and control by the state over individuals such as refugees and asylum seekers, and where there is attribution of the conduct of organs of the state to the state and breach of obligation, then responsibility flows. We also have principles of individual civil and criminal liability reflected in certain areas of international law. The challenge is to find a jurisdiction, of course, in which these might be applied. But there are some 16 countries which recognize universal jurisdiction, and therefore 16 jurisdictions at least, at which policymakers, officials, and implementers might find themselves at risk of prosecution. There is a reason why John Yoo, one of the architects of the torture memorandum in the US, doesn't travel abroad. Effectiveness. Has it been effective? Has Australia's policy adopted from the US been effective? We can't really know because of the secrecy. Perhaps 17 boats have come through and their passengers have been quietly disseminated through Australia's very efficient resettlement procedure. If a minister were to admit that, of course, then he or she would confess the failure of the policy and also have to go to jail for 2 years for breaching the 2012 Act. Has the sum of protection of solutions actually increased? That's what I would ask myself if I were considering the question of effectiveness. And again, we can't be sure that that hasn't been the case, and I very much doubt that it is indeed the case. I very much doubt that the sum of protection and solutions for refugees around the world has been increased. So what we have, I think, is a lesson coming out of Daniel's book that I mentioned a moment ago in starting, about the limits of unilateralism. And this was recognized by the General Assembly in 1946, which stressed that the refugee problem was international in scope and nature, that no state should be expected to carry the responsibility on its own, but that every state which admitted refugees was acting on behalf of the international community, and for that reason in particular should have the support of the international community, material, political, and in the provision of solutions for refugees. Thank you.
Thank you guys very much. We have about a bit more than 15 minutes now for questions, and I'm sure you all have things to say. Let me though just start out very quickly by summarising some of the key issues that I think we drew out from both of those presentations. Issues were raised around what the risks of deterrence are, and particularly what happens when states start out-competing each other in terms of deterrence. Questions were raised about lack of transparency, about these private conclaves of nation states, and about issues of secrecy. We also talked about the limits of unilateralism as opposed to multilateralism in addressing these kind of issues. Issues raised around burden sharing and perhaps a lack of clarity of each state's obligations in terms of sharing those burdens, and the importance, on the other hand, of international cooperation to do so. Issues around fear, around the lack of understanding or the lack of empathy of policymakers. I don't know how many of you have seen Ai Weiwei's documentary that's been screening recently in Sydney and around the country, but when I saw it, the first thing I thought was that it should be compulsory viewing for every policymaker and every politician should be strapped to their seats and made to watch it. Issues around control and the use of control by nation states, and also the increasing use of unaccountable discretion and how we can hold them to account. And finally, issues around the lack of strategic policy and strategic thinking, combined with a lack of evidence about the effectiveness of deterrence. So there's some of the things that came out for me. I'm sure different things came out for you. We've got 15 minutes now, and I'm sure our speakers are happy to take your questions. You have a microphone to share there. So who would like to get the ball rolling with a question or a comment? Yes, we have first question here.
Peter Hinder. Sorry, thank you. Peter Hinder. Excuse me. Then you said that the ship was turned away from Cuba and then the US. At about that time, I don't know if it was the same shipload, the ship was turned away from Australia and was turned away from Great Britain. And it was predominantly Jewish. I don't know if it's the same ship. But the thing to keep in mind when you see that is at that time, nowhere in the world were Jews welcome. That was very clear.
Should we take a couple of questions?
Sure. Okay, I think that was a comment, yes.
It was a comment, but let's take a few comments or questions together and you can respond as you like. Please.
Well, this is an actual question. You've both painted a fairly dark picture, and I think with a great deal of justification. But I wonder if there are any good guys or good girls in this picture at all. Is there any country or any jurisdiction whose example the rest of the world really should be following?
Should we take one more question now and then we'll go back to the panel? Yes?
Hello, Mary Crock here. At the moment we are seeing two global compacts put together in an attempt to find a better way for the world to deal with mass migration problems. My question to both of you is, are you disappointed that we are maintaining this strict separation between refugees and migrants? Because the moment you go into the field and you start working, as you will have seen yourself, populations are mixed. And I actually do believe that we live in quite different times today, in the sense that wherever you go, you walk into a shelter in Indonesia, as we did, for unaccompanied minors. They all had mobile phones. One of them had a satellite phone, and they are talking back to base. And so the messages that are going around are very real, and this has really changed the whole agenda for governments. And Daniel and I actually wrote a piece on this in 2010, looking at the immediacy of telecommunications and how that's stopping it. So I guess my issue, Guy, is it time for us to drop this rigid distinction between refugees and migrants? The problems are pervasive for both groups. That's the first question. The second, I have to ask you, have you been able to find, Caldor Centre people, statistics on asylum claims in Australia since 2013? Because as far as I can see, even the Human Rights Commission in Australia do not have that data. And I spoke up at a forum the other day with a group of well-meaning people, and there were individuals at the back that made it very clear that the majority view in Australia is very much that, yes, we're doing it right, and as Australia has, the success is in the boats haven't stopped coming, the boats have stopped coming. And I said to them, well, how many people have sought asylum since 2013? Nobody, they said, confidently. I don't have the statistics. I'd love to know whether you have been able to find them. But I know from working with people who are doing the asylum claims that it's probably between 5,000 and 10,000 a year that are coming here. So there's a question and an invitation.
Two very big ones. Who wants to make a response to any of those comments or questions?
Very glad that Mary was looking at my colleagues at the Caldor Centre and not at me when she asked that question. On the other issue, I had a... Is this on or not?
No.
How's that?
A little red light.
I've got a red light. Does that help? On the issue of mixed migration, I think that is a good question, and one that's right for the times. Good. I was at a conference the other day in Tasmania, and an ethicist from the Netherlands actually asked me, should we stop calling them refugees? And that caused me to start thinking, because I feel I have been moving in that direction to a great extent, in particular because of some of the issues which you raised. Another example I'll give you from the Mediterranean, which does put governments seriously on notice about the problems they're facing. This is what's come to be known as engineered search and rescue. And an Irish colleague of mine who was on one of the Irish naval rescue vessels explained how, in fact, the smugglers will send boats out. One person will be provided with a mobile phone and a speed dial number to the search and rescue centre in Rome in Italy. And as soon as they cross the territorial waters limit, they'll call for rescue. It doesn't mean it's not a rescue, because the boats, as we know, are very often overcrowded and unseaworthy. But it is engineered with a view to exploiting the possibilities that smugglers have discovered for people to get admitted into Europe. Now that's a problem, but it's not a problem in isolation. It's a problem which is also in large measure due to the fault of states in their not having internationalized the migration phenomenon at all. Refugees also, the way in which refugees have been defined and were developed, and the way in which the definition was developed and applied in practice, revealed a strong politicization of the issue, which has got in the way of effective and objective problem solving over the years. My own inclination is to move towards the notion of people who are without protection, which would encompass the refugee, the stateless person, and the migrant unable to avail themselves of the protection of the government or country of origin. But finding solutions for that migration dimension will require states to cooperate with sending countries, with transit countries, and so forth. And up to now, they haven't been prepared to do so, except in a battering and bullying way. I'm thinking in particular of Europe at the present time. And what I think policymakers in many countries need to do is to recognise that people are very often a country's only natural resource. We take countries in West Africa, Senegal, Gambia, Guinea. The amount of remittances sent back by their citizens each year, in the case of Guinea, amounts to 22% of GDP, a phenomenal amount. And so when a European country picks up a Gambian or a Guinean or a Senegalese and proposes to send them back because they are irregular in the country, how does the country of origin feel? Not that they are criminals who need to be readmitted, but they are about to lose an income stream, and the deporting state or region is providing nothing in return. And that gets in the way of what could be better, more effective, more equitable migration management. Something needs to be given in return. And because of states' unwillingness to deal with migration except in a unilateral sense, we are in large measure, that is one of the reasons why we are in the pickle that we are in today. So the changes do need to be made. And I think we need to reconsider the notion of those without protection, while also grappling with the migration dimension. So whether we should have separate compacts or not, we could argue either of them. I think that's where we are at today. I think there will be progress on both fronts. And if we can begin to internationalise in particular the migration side, if we can begin to strengthen the mechanisms for sharing responsibility on the refugee side, then we will have made some progress. Some progress. We won't have solved everything.
On the distinction between migrants and refugees, in the domestic context, it serves an important, I guess, political function. And it's on one side of politics, it's easier to defend the right of refugees to come here than migrants. So, without arguing for open migration, you need some way of identifying who are the most in need of basically our compassion. But as we've seen, it can get skewed, and we keep dividing even the refugees up into different groups. So we've got deserving refugees, who are those that wait in our resettlement program, and then the government is sort of demonising those that sort of self-select and come here by birth. In terms of the other question about good examples, it depends on what part of the humanitarian program, humanitarian response we talk about. So countries like Australia and Canada, we have really gold standard in terms of our resettlement program and selecting people through camps and bringing them here. But in Australia, we do very poorly in terms of granting access to asylum for people that try and cross our borders. And yes, I guess we need to be more specific in terms of granting asylum. It seems that for the most part, the stringency of borders correlate with the, I guess, the breadth of the social safety net that exists in a society, and we see a very clear correlation. So we have a lot of very poor countries that have completely open borders, and all asylum seekers are free to cross and enter. So I don't know if you could argue that they're doing well in this regard. I guess one of the exceptions to that rule in recent times was Germany in 2015-2016, where they really did open up their borders to close to 1 million Syrian refugees. So I guess that is an example we could emulate. But having just come back from Hamburg, where I had a book launch event there last week, it has resulted in quite a big public backlash. And so the challenge is for leaders is to take a principled approach like that, but to be able to bring the public with them. And so that's the balance that needs to be struck.
I mean, I think we've got time for one last round of questions or comments. Please, we have one here. Yes.
Thank you. My name is Georgia Sianovich, member of the public. I just wonder why it is so hard for politicians to present the case that immigrants are entrepreneurial. They are, and given that in first world countries the birth rate is declining, immigration is a very, very important for our economies. Could we not just create a new narrative around that and just keep emphasizing that aspect? And that was the main reason why Angela Merkel also invited 1 million refugees to come to Germany, because of the declining birth rate.
Any other questions, comments? Sorry, thank you.
Glenn Robinson, I'm a member here. This is a question. If we stopped the bombing the Middle East, would the refugee problem disappear? And largely, would the migration problem also be significantly reduced?
Do I see up the back here first?
Thank you, Lina Garcia. My question is for Dr. Guy, if possible, and you were mentioning that one of the solutions would be to assume responsibility, that states can assume responsibility not in an individual basis, but as part of the international community. And in that sense, that the international community should cooperate like as part of an international response. So under that logic, would it be possible to think, instead of as a reactive measure, once you have the refugees as part of your national problem, think about a preventive measure of international cooperation to prevent that to happen and to prevent wars to still happening, and like political prosecution and so on and so forth?
And last, I saw some hands over here. Last one or two. Anyone?
Thank you, Libby Lloyd. I was interested in Guy's comments about Australia failing to find innovative policy solutions. I look back to 1979 when we had a good global solution, and the effort by Australia in, I think, 2011 with the Malaysia solution, which failed. It seems that we get stuck constantly with the wicked issue of our partisan politics, and I'm not sure how Australia, with its present political system, can find a way for a regional solution or a global solution.
Thank you. Guy, would you like to start?
Thank you very much. First of all, on the economic dimensions to promoting refugee resettlement, I think there's a lot that can be done there, a lot can be made of that issue. Graham Hugo, the late Graham Hugo, did some very interesting research on the contribution of refugees to the economy, which were very positive. My only regret here is that these sorts of arguments tend not to carry a great deal of weight with the public at large. And certainly we saw that, to step outside the refugee box for a minute, in the Brexit discussions, debate in the UK before that fatal vote was taken. The economic arguments just didn't carry weight, it was the emotive arguments that did it. So yes, I believe we should emphasise the economic contribution of refugees. We need to need to back it up with, I think, of course, to what I find very present in the community, which is basic humanity. And I see that daily, in every contact I have with those who are visiting Billerwood or other detention centres, a great deal of common humanity and distress at the manner in which people are being treated. And I think that's something we also need to build on. If the bombing in the Middle East ceased, would that be an end to the refugee problem? Not immediately, no. If you look at the pictures of destruction, for example, in Syria, you can see that there is a 20-year rebuilding plan ahead. A new Marshall Plan, if you like, will be needed for Syria in order to enable refugees, if they wanted to, and were able to go back and contribute to rebuilding their state. So there's a long-term strategic plan that needs to be put into place on that account. On the issue of international cooperation, reactive, you're absolutely right. The system was set up to be reactive. From an international law perspective, you don't become a refugee until you cross an international frontier. And indeed, that was part of the thinking in the 1940s and 50s when they put together the statute for the UN High Commissioner for Refugees, the issue would only be a matter of concern for the UN once it became international. States were very jealously guarding their sovereignty at that time. They didn't want the UN to intervene in what they perceived to be their domestic affairs. And that opposition has continued to this day. States are very reluctant to give their accord to actions by the UN or by states acting through the UN, which might, for example, prevent the necessity for flight. Not prevent flight itself, because you have a right to seek asylum from persecution. Prevent the necessity to remove the conditions. And I do often think that with the benefit of the clear vision that hindsight gives you, whether someone might not have intervened successfully in Sri Lanka to prevent the adoption of that legislation, which in effect led to the Tamil secessionist movement, or have intervened vis-à-vis Vietnam to persuade them not to go the ultra-socialist path of re-education and abolition of the bourgeoisie, whether that might have been more effective. We're not very good at that sort of stuff, let alone at mediating conflicts in Syria. And then on I think, Libby, you answered your own question, we're just not up for it yet, are we?
I just want to echo Guy's point on the ineffectiveness of economic arguments for justifying refugees. What we're dealing with what are very deeply held convictions of people about their fear of the other. And no amount of economic incentive is going to be able to shift their opinion on this. The only way we can change public opinion is to engage with values, as Guy said, common humanity, engaging with the intrinsic values people already hold, and demonstrating that a compassionate approach is the only approach that's consistent with those beliefs. Taking the next two questions together, I think the one thing that everyone agrees on, no matter your political persuasions in this area, is that dealing with the root causes of refugee movements is the best solution. It's much easier said than done, but I take the point that perhaps we shouldn't be contributing to those root causes. At the very least, we can refrain from causing new movements through bombings and so on. And just on Australian politics, and I know I painted a bleak picture, but that was, I guess, the worst case scenario that I painted in my presentation. And I do think there is hope, and it's really going to be about prosecuting arguments in the court of public opinion. And part of a large part of my book, which I didn't address today, was looking at the case law challenging these policies in Australia and the United States. And basically the message was that the courts are not going to be an effective bulwark against these policies as long as and the legal protections in Australia and US law, and I'd also argue even in Europe, because with their stronger binding supranational human rights protections, as long as there is a belief amongst policymakers that the public wants these restrictive policies, governments will find a way to, I guess, negotiate and navigate the legal impediments and provide those policies. And so we have to prosecute our argument in the court of public opinion, and going back to my earlier point, appeal to the intrinsic values that people hold, and it's going to be very difficult, but I don't think it's going to be impossible.
Thank you. Well, we're a little bit over time. Thank you very much for your questions. Thank you all for joining us in the discussion, and would you please join me in thanking our presenters and the organisers.
Many thanks, Leanne, and thanks to the audience for providing such a lively and interested crowd for us tonight. Also, my personal thanks to Francis Spoon for doing so much to make this evening happen. To round the evening off, our intern Chris Katuhi will now move a vote of thanks.
I'd like to thank our speakers today, Leanne Smith for her role as moderator, Dr. Daniel Gezelbash for highlighting that in moments of desperation, governments find it increasingly easy to look abroad for quick solutions, yet secrecy and a lack of transparency has created a conclave of like-minded policymakers with disastrous effects on a global scale. Professor Guy Goodwin-Gill for highlighting that Australia and other countries have fallen victim to the lure of unilateralism, and that an out-of-control executive is undermining not only the livelihoods of refugees, but our democratic institutions we take for granted. I think you both make it very clear that the barriers we place on our borders and the fears we foster in our societies against refugees do not work in real life, but only in our minds. On behalf of the Institute, I would like to sincerely thank you for coming today and speaking with us.